There are mainly two classifications of the law. First, international law, and the second one is municipal or national law. Now, what is international law? The present form of international law is of recent origin. Some earliest jurists were of the view that international law is not law as it lacked many elements which law should have. Austin and his supporters were of this view. Some say international law is law and is superior to the municipal law. Kelsen supports this view. The legal process that concerns legal relations among nations is called international law. Belief and experience, some form international law dates from at least the days of Roman Empire. The United Nations is of the primary mechanism that articulate and create international law. The major source of international law are multilateral treaties, international custom, and such general principles as recognized by the civilized nations. According to some jurists, international law may be divided into two classes. First, public international law and private international law. Public international law is that body of rules which govern the conduct and relations of the states with others. Really speaking, the term international law is used for this class of law. Private international law means those rules and principles according to which the cases having foreign element are decided. For example, if a contract is made between an Indian and Pakistani and it is to be performed, the rule and the principles on which the rights and the liabilities of the parties would be determined would be called private international law. This class of law is called conflict of laws also. After knowing the field of application of this class of law, it is clear that the adjective international is wrongly given to it because it applies to individuals and not to states, and these rules and principles called private international law vary from state to state and thus lack uniformity. This class of law is enforced by municipal courts which administer municipal law and not international law. So, such a law does not possess the characteristics of international law. In modern times, this class of law has gained much importance and every state has made rules for its administration. Therefore, it must be properly classified. It is submitted that it should be given in the name conflict of law and not private international law, and should be treated as a branch of municipal private law and should be classified as such. Now friends, what is the municipal law or law of land? The municipal law is also known as law of land or civil law or law applied within a state. This is divided into two classes, public law and private law. Now what is public law? The state activities are largely regulated by public law. It determines and regulates the organizations and functions of the state and determines the relation of the state with the subject. Public law may be divided into three classes. First, constitutional law. Second, administrative law. Third, criminal law. Now, what is constitutional law? By constitutional law is meant that law which determines the nature of the state and the structure of the government. It is above and superior to the ordinary law of the land. Constitutional law is the basic law or fundamental law of the state. The constitutional law may be written as in India or unwritten as we find it in England. In modern times, there is a tendency to adopt written constitution. Now, what is administrative law? Administrative law deals with the structures, powers, and the functions of the organs of the administration, the limits of their powers, the methods and the procedure followed by them in exercising their powers and functions, the methods by which their power are controlled, including the legal remedies available to a person against them when his rights are infringed by their operation. Now, what is criminal law? Criminal law defines offenses and prescribes punishment for them. Its aim is to prevention of the crime and punishment for such offenses. Criminal law is necessary for the maintenance of the order and the peace within the state. In civilized societies, crime is considered to be wrong not only against the individual who has been wronged, but a wrong against the whole society. Therefore, the state initiates the proceedings against the offender and thus it is always a party in criminal cases. This is why the criminal law is considered as a branch of public law. Now, let us discuss the private law. This branch of law regulates and governs the relationship of the citizens with each other. The parties in such a case are private individuals and the state through its judicial organ adjudicates the matters in dispute between them. In these cases, the state takes the position of only an arbiter, but it does not mean that the state regulates all the conducts and the relations with citizens, but regulates only such of them as are of public importance, and these relations which state regulates constitute the civil rights of the citizens. The major part of the municipal law consists of this branch of law, but in totalitarian states, the public law regulates the major part of the social life. In the classification of private law, there is a great difficulty. Different jurists have given different classifications. A very general classification that has been given is, first, the law of persons, the law of property, the law of obligations, and the conflict of laws. The law of obligation is divided further into three classes. First, contract, quasi-contract, and the tort.